Chat more now about Advocate Busisiwe Mkhwebane's first day, speaking for the first time as someone who's giving evidence today at the inquiry into her fitness to hold office. We're joined by governance expert Dr. Koma. Dr. Koma, very good evening to you. Thank you so much for being with us tonight. Has Advocate Mkhwebane done a good job on day one of setting out why she feels that she is properly suited to be public protector and why she says the push to have her removed is politically motivated?
Well, thanks, Tembekile, for the opportunity. I think it should be understood that suspended public protector Ms. Mkhwebane is the last witness to be heard before the inquiry committee in terms of their lineup of witnesses. So far, we have heard testimonies from various witnesses testifying for and against the suspended public protector. Now it is an opportunity afforded to her to state her own side of the story against the charges leveled against her, one on misconduct and two around incompetence. So it is perfectly understandable for the public protector during her first day of the testimony to put out a clear testimony that speaks to her defense, to say, I've carried out all the investigations within the confines of the powers and functions bestowed to me in terms of the Constitution and also applicable legislation, which is the Public Protector Act. And I'm here to testify that I have what it takes to deliver on my constitutional mandate. And all the witnesses who came before this committee testifying that, one, I don't understand my constitutional mandate, I'm incompetent, and also raising issues around misconduct are totally wrong. Please take my side of the story as part of my defense. So the committee has reached an advanced stage. They are now going to of course, hear the side of the suspended public protector. Today is day one. We know that her testimony has been scheduled until end of this month. So it's still early days.
And there exists already a level of tension between the suspended public protector and, for example, the Democratic Alliance. There's also tension between herself and the chairperson of the inquiry, whom she's accused of bias against her. So once all of this is wrapped up, can the politicians who are on this committee really divorce themselves from their political party views, their personal views of Advocate Mkhwebane, and the conduct perhaps of her legal team in their deliberations, which will ultimately shape whether or not she's deemed to have been fit and proper or not?
Yes, thanks, Tembekile. Unfortunately, the design of our Constitution in this regard gives power to the National Assembly to conduct an inquiry against any head of a Chapter 9 institution who might have been alleged to have misconducted herself or himself or is alleged to be incompetent. So the powers of the committee are directly taken from the Constitution. They are exercising that constitutional obligation bestowed to the committee to run with an inquiry and at the end of the day make findings and also come up with recommendations before the National Assembly for consideration. Bearing in mind that to remove a sitting public protector, Parliament will have to secure a 2/3 majority supporting such a motion. Okay, so there's nothing untoward at this stage. The committee is a committee of Parliament. Of course, they're acting in line or in accordance with their powers provided for in Section 194 of the Constitution.
But is it safe to say that this inquiry, when it does publish its report, whether it is a finding in favor or against Advocate Mkhwebane, it's a sort of report because of the political dynamics around it that it will no doubt, or possibly I should say, face some kind of legal challenge?
Yes, we can't divorce politics from the whole exercise. The beauty about this exercise is that at the end of the day, once the committee concludes its business or its work, they're going to afford Ms. Mkhwebane an opportunity to make presentations based on the outcomes and the recommendations of the inquiry work. And at that stage, she'll be at liberty to challenge the findings and the recommendations, and subsequent to that, that process will then lie in the hands of the National Assembly to make a determination. So we can't preempt that in the final analysis, the National Assembly will pass a 2/3 majority supporting vote calling for the removal of the public protector. We can't make such a prejudgment. But it's very important to indicate that beyond the parliamentary process, the public protector, even if she goes to court to challenge the outcomes, the court will still agree with Parliament undertaking such a process because it falls within the ambit of the Constitution.
Right, and because she's already complained of perceived or real unfairness in the run-up to her appearance today, I'd imagine the next few days, especially when she's going to be led through some of her evidence or ask questions from the other side, what's going to be important is that she is seen to be treated very fairly by the people running this process, right?
Yes, and that's what the chairperson of the inquiry assured her and all the witnesses who came before the inquiry to say, we are following a due process. You are afforded an opportunity to be represented by your own legal representative, and that is the reason we have Ms. Mkhwebane being legally represented by Advocate Dalimpofu. It falls within her right to do so, and the rest of the other witnesses who have come before the committee. But you have the evidence leader who plays a neutral role between the two parties, that is Parliament and also the suspended public protector, to make sure that at the end of the day, the outcome of this process is not seen to be tainted, it's not seen to be a partial process, but it is seen to an impartial process that favors all the parties that are involved in the process.
Dr. Sam Koma, good to speak to you. Thank you so much for your time tonight.